Welcome to Environmental Intelligence, episode 27 for April 23, 2026. Here's what changed overnight in the environmental regulatory landscape. The Supreme Court ruling in favor of Michigan on the Enbridge Line 5 pipeline sets a precedent that Canadian practitioners should weigh when supporting federal or provincial pipeline applications near international boundaries. Competing pressures on Canada's climate policy continue to create regulatory uncertainty for projects touching oil sands, mining, and emissions-intensive infrastructure. A proposed Wisconsin pipeline crossing 200 waterways and 100 acres of wetlands highlights parallel risks for linear infrastructure approvals. Practitioners should monitor cross-border legal outcomes and domestic policy tensions this week, particularly where they intersect with CEPA and provincial EMA and EPEA obligations. The Supreme Court ruled in favor of Michigan in its long-running effort to shut down the aging Enbridge Line 5 pipeline. The decision affirms state authority to enforce environmental protections on infrastructure traversing the Great Lakes, overturning lower court stays that had allowed continued operation. For Canadian practitioners, this outcome strengthens arguments that international pipelines must satisfy both domestic risk thresholds and downstream jurisdictional requirements. That is especially true where Fisheries Act authorizations or Species at Risk Act considerations apply. Current projects proposing new or continued cross-border crude or natural gas lines should now anticipate heightened scrutiny of aging infrastructure integrity, spill modeling, and cumulative effects on shared waters. Counsel and consultants supporting National Energy Board or provincial regulator filings are advised to incorporate the Michigan precedent into comparative risk registers immediately. What this signals is that downstream ecological connectivity can no longer be treated as a secondary consideration, even when the Canadian segment appears straightforward on paper. Watch for any federal response on Line 5's Canadian segments and potential alignment with upcoming IAA amendments. Federal and provincial climate policy faces intensifying tension between emissions reduction targets and economic pressures from oil sands and mining sectors. This directly affects compliance planning for projects under CEPA, provincial EMA approvals, and carbon pricing regimes. Practitioners should review current client portfolios for policy risk exposure and prepare adaptive compliance narratives ahead of any forthcoming federal adjustments. What I find notable here is how this tension keeps surfacing in nearly every major project I see crossing provincial or federal desks right now. Wisconsin regulators are reviewing a pipeline proposal to transport 23 million gallons of oil daily across more than 200 waterways and 100 acres of wetlands. The project mirrors Canadian linear infrastructure challenges under provincial wetland policy and federal IAA screening. Consultants supporting similar Canadian projects should benchmark spill contingency and habitat offsetting strategies against this proposal's environmental commitments. New modeling shows climate-driven changes are reducing coral larvae dispersal distances across ocean basins, lowering reef recovery potential. While not domestic, the biophysical connectivity principles have direct analogs in Canadian marine risk assessments for coastal contaminated sites and mining effluent discharge under the Fisheries Act. Practitioners assessing long-range transport of contaminants or adaptive management for Pacific or Atlantic marine projects should note the shrinking recovery window implied by altered larval or equivalent particle travel. The GoFlow AI method converts existing weather satellite temperature data into high-resolution maps of previously unobserved small-scale ocean currents critical for climate, ecosystem, and carbon storage modeling. Canadian practitioners supporting marine environmental assessments or contaminated sediment transport studies in coastal zones can apply similar satellite-derived approaches to improve hydrodynamic inputs for fate and transport models. The cost-effective use of already orbiting assets aligns with federal and provincial requirements for best available science and impact predictions. Consumer beef demand in multiple countries is quantitatively linked to accelerated land clearing in the Brazilian Amazon, reducing regional carbon storage capacity. For Canadian oil sands and mining practitioners, the study reinforces the need for robust Scope 3 emissions accounting and land use change considerations when reporting under federal or provincial climate disclosure expectations. Data centers impose approximately $25 billion in annual hidden damages to environmental and public health through energy, water, and emissions burdens. For Canadian consultants advising on hyperscale facility permitting under provincial EMA or municipal approvals, this underscores the necessity of full life cycle impact quantification beyond simple greenhouse gas reporting. Early integration of these externalities into client feasibility studies can reduce future regulatory pushback and remediation liabilities. Permits reviewed for projects linked to major tech firms indicate potential annual emissions exceeding 129 million tons of greenhouse gases, surpassing outputs of some entire nations. Practitioners supporting energy infrastructure or industrial approvals in Alberta, British Columbia, or Ontario should stress test client proposals against comparable intensity benchmarks to anticipate CEPA and provincial climate plan conflicts. Allbirds is de-emphasizing its prior environmental mission in favor of AI-driven priorities. While a single corporate example, the shift signals broader market pressure on voluntary sustainability commitments that Canadian remediation and consulting firms often rely upon when marketing ESG-aligned services. If you are working on existing or proposed cross-border pipeline files, review them now for opportunities to incorporate the Michigan Line 5 precedent into spill and integrity risk narratives. Update client climate policy risk matrices to reflect ongoing federal-provincial tensions reported in Canadian climate policy coverage. Extract hydrodynamic and connectivity principles from the new ocean current AI method for application to upcoming marine or coastal sediment transport assessments. Brief energy sector clients on the quantified hidden costs of data center infrastructure to strengthen lifecycle impact sections of pending EMA applications. Scan upcoming federal IAA or provincial wetland policy consultations for language that may reference international legal precedents on linear infrastructure. April 28th to 30th federal provincial climate policy coordination meetings are expected to address competing economic and emissions pressures, so prepare briefing notes for clients with oil sands or mining exposure. April 30th marks the anticipated close of public comment period on several provincial wetland compensation guidelines, so verify exact deadlines in British Columbia, Alberta, and Ontario. May 5th brings CCME quarterly working group calls on interjurisdictional contaminated sites guidance, so practitioners should confirm agenda items related to cross-border data sharing. May 15th is the next scheduled Canada Gazette publication window for any CEPA amendments arising from recent international pipeline or climate rulings, so monitor for early signals. Now, speaking of cross-border pipeline precedent risk in Canadian regulatory filings, here is something worth thinking through before your next submission lands on a regulator's desk. Imagine you are finalizing an environmental impact statement for a new liquids pipeline segment that crosses into United States territory near the Great Lakes. The Michigan Supreme Court decision on Line 5 now sits on your desk as opposing counsel cites it to challenge the adequacy of your spill contingency and aging infrastructure management plan. In practice, this triggers parallel review under the Federal Impact Assessment Act physical and social environment factors plus provincial EMA or EPEA approvals for the Canadian right-of-way. Experienced practitioners recognize that United States state-level environmental victories create de facto higher bars for Canadian projects even when Federal National Energy Board or Canada Energy Regulator processes remain nominally independent. The key nuance is that downstream ecological connectivity, particularly for Fisheries Act fish and fish habitat, cannot be siloed. Modelers must now run scenarios that explicitly incorporate the precedent's emphasis on irreversible harm from leaks in sensitive aquatic systems. What separates senior practitioners is the early insertion of comparative jurisdictional risk tables into the regulatory submission rather than waiting for interveners to raise them. The most common mistake is treating the United States decision as purely foreign law with no domestic weight. The fix is to proactively model the precedent's logic in your own risk assessment and offer enhanced monitoring or financial assurance commitments before the first public comment round. Before we wrap, watch for any early federal signals on how Ottawa intends to respond to the Line 5 ruling in upcoming IAA or CEPA discussions. That covers today's environmental intelligence. If you found this useful, share it with a colleague who needs to stay current. We're back tomorrow morning. This podcast is curated by Patrick, but generated using AI voice synthesis of my voice using ElevenLabs. The primary reason to do this is I unfortunately don't have the time to be consistent with generating all the content and wanted to focus on creating consistent and regular episodes for all the themes that I enjoy, and I hope others do as well.